Welcome to this explainer. Today we are going to break down the complex and, let's be honest, often totally misunderstood reality of how medical negligence law actually applies to psychiatry right here in Scotland. Our goal today is pretty simple. We want to empower you with the specific, actionable knowledge you need about your legal rights when mental health care falls short.
Okay, let's dive right into this by asking a really crucial question. Think about it. If a surgeon operates on the wrong knee, boom, the patient immediately knows a mistake happened, right? They speak up. But what happens when mental health care goes wrong? Like when a patient is misdiagnosed for an entire decade or suddenly discharged right in the middle of a crisis. There is this profound, almost unique silence around mental health care failures. In so many of these cases, the patient wrongly blames themselves, or they blame their illness, or they simply never realize that the harm they suffered actually has a name in the eyes of the law.
So to answer why that silence exists and how we can break it, this explainer is broken down into 5 vital sections. We'll start with the reality of psychiatric negligence, move on to the Scottish legal standard, look at some common failures in care, discuss why detained patients absolutely have rights, and finally we'll wrap up with time limits and claiming compensation.
All right, let's jump straight into Section 1, the reality of psychiatric negligence.
You see, this is a deeply misunderstood area of Scottish law. On one side, you have surgical harm, which is visible and immediate. But on the other hand, psychiatric harm, well, that often operates in the shadows. But make no mistake here, while psychiatric negligence might be one of the least discussed areas of medical negligence law in Scotland, the harm it causes, the devastation to relationships, to careers, to someone's physical and mental well-being, that can be just as profound as a slip of a scalpel.
Moving right along, Section 2, the Scottish legal standard.
Now, under Scottish law, psychiatrists are doctors, meaning they are treated on the exact same legal footing as a surgeon, a dentist, or your general practitioner. The crucial point here revolves around a 1955 case called Hunter versus Hanley. This case is literally the absolute foundation of medical negligence law in Scotland today. The legal test asks a very specific question. Did the professional act as no reasonably competent practitioner in that field, acting with ordinary skill and care, would have acted? That exact wording matters a lot. It sets a deliberately demanding standard because, let's face it, medicine, and psychiatry in particular, involves incredibly difficult judgment calls.
Basically, the law doesn't punish a bad outcome. 2 completely competent psychiatrists can look at the exact same patient and reasonably come to totally different conclusions. That is not negligence. Negligent care, on the other hand, is care that falls completely outside the range of responsible psychiatric opinion. We're not talking about a treatment that simply didn't work out. We are talking about a diagnosis that literally no competent psychiatrist would have missed based on the clinical notes. Or, say, a mandatory blood test that national guidance required, but for whatever reason, nobody ever bothered to order.
Which brings us to Section 3, common failures in care.
Let's get into the practical side of things and explore the specific clinical battlegrounds where these negligent failures most commonly happen. A huge thread in these claims is misdiagnosis, which often results in what we call the missing years. Now, an initial misdiagnosis isn't automatically negligent, but claims pop up when the evidence pointing to the correct diagnosis is repeatedly recorded by staff but totally ignored. Take bipolar disorder, for example. If a patient is mistakenly treated for depression, those antidepressants can actually trigger the elevated mood episodes that define bipolar disorder. So if a patient spends a decade cycling through antidepressants with documented manic episodes that are just ignored until a brand new clinician finally reads that exact same file and gets it right, one expert is going to ask, at what point would a reasonably competent psychiatrist have figured this out? Every single year after that point is a year of avoidable harm. This exact same pattern happens when things like trauma-related personality disorders are missed or physical conditions like thyroid disease are just never tested for.
Then we have medication. For certain unforgiving drugs, the standard of care is absolutely not up for professional debate. It's written down in black and white in national prescribing guidance. Take lithium. It's an incredibly effective treatment for bipolar disorder, but it has a very narrow margin between a therapeutic dose and a highly toxic one. It requires strict monitoring of blood, kidneys, and the thyroid. If that lapses, toxicity can cause permanent kidney damage. In these scenarios, the claim doesn't turn on some complex clinical judgment call. It literally turns on exact dates on a calendar. When did the guidance say the tests were due, and when were they actually done? The exact same strict rules apply to clozapine and its mandatory white blood cell monitoring.
Medication claims also tie heavily into informed consent. There's this landmark 2015 Scottish case, Montgomery versus Lanarkshire Health Board. It went all the way to the Supreme Court and adds some real teeth to psychiatric care.
The ruling states that a doctor absolutely must ensure the patient is aware of the material risks of a treatment. In psychiatry, long-term medication can cause massive weight gain, movement disorders, or even metabolic disease. If a patient develops a known but totally unmentioned side effect, and they can show they would have chosen a different path had they just been informed, they might actually have a valid claim. And that's true even if the initial decision to prescribe the drug was technically competent.
The most serious claims we see, however, involve failing to competently assess risk when patients are at their absolute most vulnerable, on admission, on leave, or upon discharge. Now, look, the law doesn't demand perfectly accurate predictions of human behavior. That's literally impossible. But it absolutely does demand that decisions be made competently based on the information that is actually available right then and there. Discharging a patient while known risk factors are still unaddressed, ignoring documented warning signs reported by terrified family members, or failing to carry out prescribed observation levels on a ward, these are the critical systemic failures that lead to truly devastating outcomes. Tragically, when a psychiatric failure leads to a preventable death, the claim passes to the family. Under the Damages Scotland Act of 2011, close relatives can pursue a civil claim for their grief, the loss of financial support, and funeral costs. Now, families often tell us that compensation isn't their primary motivation at all, and that is absolutely valid. Often, a civil claim is literally the only process with the power to compel the full disclosure of medical records and force a real, reasoned answer as to what went wrong. It's a process that proceeds completely separately from any public interest fatal accident inquiry.
Okay, moving into Section 4. Detained patients have rights.
We absolutely must carve out some specific space here to dispel a persistent and frankly highly damaging myth. There's this totally false belief that if you are detained under mental health legislation, you somehow lose your right to complain about your care. Guys, the exact opposite is true. Because the state has stepped in and placed you under care via the 2003 Act, you are owed the exact same, if not a significantly heavier, duty of competent care because you literally cannot go out and seek care elsewhere. Furthermore, if a patient is detained without the strict statutory criteria being met, or if safeguards like the Mental Health Tribunal are bypassed, that unlawful detention forms the basis of an entirely separate legal claim, regardless of the treatment you actually received.
And finally, Section 5, time limits and claiming compensation.
Let's unpack the mechanics of justice here, specifically how time limits work. You might be surprised to hear they are actually a bit more generous in Scotland than many people assume. The general rule under the 1973 Act is a 3-year time limit to bring a claim. But here's the critical part. That clock does not start ticking on the date of the negligent care. It starts from the claimant's date of knowledge. That's the point at which they knew, or reasonably should have known, that they suffered harm due to fault. Because psychiatric patients often only realize they were harmed years later when a brand new doctor reviews their history, this rule is a real game changer. Plus, the clock completely pauses during periods of legal incapacity, meaning if a patient was too unwell to understand what happened to them, the time limit only begins when their capacity returns. It's built this way to ensure fairness in the system.
If a claim is successful, the compensation is rigorously structured into 2 main parts. First up is pain and suffering. This covers the psychiatric injury itself, plus any physical harm, like that kidney damage from unmonitored lithium we mentioned earlier, and it's assessed using the Judicial College guidelines. The second part is financial loss. This covers the tangible, day-to-day devastation, things like lost earnings, the cost of private therapy needed to actually recover from the negligence, and family care provision. It ensures victims are supported wholly and practically.
So how does it all happen? The process of claiming moves very systematically. Step 1. The full medical records are recovered, because frankly, these cases are ultimately won or lost in the notes. Step 2. An independent expert psychiatrist reviews those records to test if the care met that demanding Hunter versus Hanley standard we talked about. And finally, resolution happens either via negotiation or litigation. And crucially, this whole process carries absolutely no financial risk to the patient. It's handled on a no-win, no-fee basis. And I want to be really clear here. It has absolutely zero effect on your entitlement to ongoing NHS care.
I want to leave you with this empowering final thought. Psychiatric care in Scotland is held to the exact same legal standard as every single other branch of medicine. You have legal rights. So if you suspect that what happened to you or to someone you love was more than just bad luck or a difficult illness, will you take the step to uncover the truth hidden in your medical records? Thank you so much for joining me for this explainer. Keep questioning, keep learning, and absolutely always know your rights.